Thank you, Richard, and welcome, ladies and gentlemen of the jury. If you'll all raise your right hands, I will ask you to, do you each solemnly affirm that you will well and truly answer such questions as may be asked of you, touching upon your qualifications to act as trial jurors in the cause now pending before this court? If so, say I do. Okay, may we have appearances for the record? Counsel, we'll start with Ms. Hayes.
One moment.
Julianne Hayes, representing the plaintiff, Deborah Mulligan.
Good morning, Your Honor.
Thank
Dan
you.
Friedenthal, appearing on behalf of defendant Walgreens.
Thank you. Jury duty, of course, is one of the most important obligations we have as citizens in a democratic society. Because of its importance and because you people will be viewing this trial online via webcam, I want to give you some special instructions in order for you to be able to best conduct yourselves as prospective jurors to ensure the parties receive a fair and impartial hearing of the case. First, you should secure yourselves in a location where you will not be interrupted or distracted while court is in session. This will ensure that you will give your undivided attention to the proceedings. Please turn off all other electronic devices and only have the single browser window open for the link to the court proceeding while we are in session. You must be able to be seen by the parties at all times during the trial. You are also not to record any of the trial on any electronic device. If you lose a connection to the trial for whatever reason, please contact Irene immediately at 203 area code 496-8939, and you will receive instructions on how to log back in. We do have planned breaks. Do not log off when we take a break. If any of you need a break before one is announced, please wave your hand to get the attention of our bailiff. We will try to be flexible. As the trial proceeds, you will hear opening statements, see witness testimony, and exhibits, hear closing arguments, receive jury instructions to guide your deliberations, and deliberate with your fellow jurors. In viewing the presentations of the attorneys and witnesses, you are only to consider the evidence in the case. Do not favor one side or the other because they appear to have better computer equipment, technological proficiency, lighting, or backgrounds. The parties have stipulated to most exhibits, but if an issue does come up about evidence, we may have what is called a sidebar conference to discuss evidentiary issues. If I decide the evidence should be admitted, you will receive the evidence. If I decide it should not be admitted, you will not receive it. The fact that a party may or may not challenge evidence is of no importance about how you decide the case. Do not hold it against either party. I hope we can keep the sidebar conferences to a minimum and short, so please remain online. Because of the expedited nature of this trial, you may feel like you've not heard all the evidence you would like. However, you are not to speculate or guess about evidence you have not heard. If any of you have questions while you are listening to the witnesses, please write them down on a notepad, and then at the end of the witness, we will ask if you have any questions. If so, please raise your hand, and then a box will come up and you will be able to type the question into the box. You must keep an open mind and must not let bias, prejudice, or public opinion influence your decision. You should not form or express an opinion during trial and should reach no conclusion in this case until you have heard all of the evidence. The arguments of counsel and the final instructions as to the law that will be given to you by me. You must decide the case based only on the evidence received in this trial. You must not conduct your own investigation or research into the issues in this case, whether with books, magazines, journals, or especially the internet. The case involves a civil dispute Deborah Mulligan filed this lawsuit. She is called a plaintiff. She seeks damages from Walgreens, who is called the defendant. Deborah Mulligan claims she became injured when she slipped on debris while shopping at Walgreens. She claims Walgreens was negligent to allow the condition to exist. Walgreens denies that it was negligent and asserts that it was the plaintiff who was at fault for her injuries. You have been divided into 3 groups. We will be calling you in one group at a time for a process we call voir dire, where the attorneys get to speak to you and ask questions about any experiences or opinions that may affect your ability to be fair and impartial jurors. We all have experiences and opinions that affect how we see the world, so please be completely candid with the attorneys in this process. Parties have a right to dismiss jurors they believe may be biased or may not be able to follow the law. This is called a challenge for cause. I will hear these challenges and decide whether they should be granted. They also have a right to dismiss jurors who feel they will not be best for their case. This is called a peremptory challenge. If a juror is dismissed, do not speculate as to the reason or as to which party made the challenge. The fact that jurors are dismissed has no bearing on how the case should be decided. As jurors, you are being asked to make very important decisions involving a serious matter for both parties. So we thank you for your service. We also know that each of you filled out the jury questionnaires, which the attorneys have reviewed, but we still have some basic questions to ask here in open court. We will now turn to Group 1 to begin our voir dire. So if we could just bring in Group 1 right now.
One
We
moment,
will have
Judge.
10 jurors.
One moment, Judge. We will just need to
Okay.
remove the rest of our jurors. One moment, please.
For those viewers who are watching, we've decided to do this voir dire process within groups. So instead of voir diring the entire jury panel, we would be bringing in a group at a time that the attorneys would then voir dire, and then we would see how that goes, and then we'd move into the other group.
Okay, Judge, you have the first group. Thank you.
All right. Okay, we're going to start with juror number 1. You've all been given numbers, and that's how I'm going to refer to you. So, juror number 1, could you let us know whether you have an occupation, and if so, what is it?
Hi, I'm a jury consultant with trial behavior.
All right. And have you ever served in a jury?
I have not.
Okay. And do you believe you can keep an open mind until all of the evidence is heard? The attorneys have argued the case, and you have a chance to deliberate with the other jurors.
I think so, yeah.
Thank you. Juror number 2, do you have an occupation, and if so, what is it?
Yes, I do. I'm a professor at a university in the state of Oregon.
All right. And have you ever served in a jury?
I have not.
And do you believe you can keep an open mind until all of the evidence is heard and the attorneys have argued the case and you have had a chance to deliberate with the other jurors?
I do.
Thank you. Okay, juror number 6. Do you have an occupation, and if so, what is it?
I'm retired.
Have you ever served in a jury?
No, I have not.
Okay. And do you believe you can keep an open mind until all the evidence is heard, the attorneys have argued the case, and you have had a chance to deliberate with the other jurors?
Yes, I can.
Thank you. Okay, juror number 7. Do you have an occupation, and if so, what is it?
I am retired.
Okay. Have you ever served in a jury?
No, I have not.
Okay. And do you believe you can keep an open mind in this case until you've heard
Yes,
all
I
the
can.
evidence? Okay, good. Juror number 10. Do you have an occupation? And if so, what is it?
Yes, I work as a researcher
In what kind of research?
for a trial consulting firm.
Okay, thank you. Have you ever served in a jury?
No, I haven't.
And do you believe you can keep an open mind until all the evidence is heard?
Yes, I do.
Thank you. Juror number 9. Do you have an occupation? And if so, what is it? I didn't hear you there.
I am retired.
Okay. Have you ever served in a jury?
Yes, I have.
And don't tell us how the case was resolved, but was a decision reached?
Yes.
Okay, good. Do you think you can keep an open mind till you've heard all the evidence and arguments of counsel?
Yes, I do.
Thank you. Juror number 15. Do you have an occupation? And if so, what is it?
I'm an actor and a theater teaching artist.
Okay. Have you ever served in a jury?
No, I haven't.
And do you think you can keep an open mind until all the evidence and arguments have been heard?
Yes, I do.
Good, thank you. Juror number 13, do you have an occupation? And if so, what is it?
Yes, I do. I am the Director of Research at Talking Books. We record books for the blind.
All right. And have you ever served in a jury?
I have not.
Do you think you can keep an open mind until all the evidence is heard and the attorneys have argued?
Yes, absolutely.
Great, thank you. Ms. Hayes, would you like to inquire at this point?
Yes, thank you, Your Honor. Good morning, and thank you for being here today. I introduce myself. I'm Jillian Hayes, and I represent the plaintiff in this case, Deborah Mulligan. I know this process can be a little uneasy, especially now that we're using this new technology, but I want to assure you that there are no right or wrong answers to any of these questions. All that we are asking for is complete and brutal honesty. So as you heard from the judge, this is a personal injury case. It's a slip where my client injured herself. And now is the time I'm asking for that brutal honesty. We need to know how many of you have a bad taste in your mouth about this kind of case. When you hear personal injury, a slip and fall, trip and fall, does that bring up any emotion right off the bat? And for purposes of this, I think it may be clearest to just raise your hand and then we can kind of go down the line. So does anyone automatically have some bad feelings about a personal injury case, a slip and fall? Anybody? Okay, number 10. Okay, thank you for being honest and brave to be the first one. So juror number 10, can you elaborate on those feelings?
Yeah,
I don't know if I would say it's a particularly intense feeling, but I do have an aunt who was injured not in a Walgreens, but in a Lowe's when a staff member left a pallet in an aisle, which was against company policy.
Okay. And if you wouldn't mind sharing a little bit more, do you know if there was a lawsuit that resulted from that?
I don't know a lot about it. I know that she did sue, and it took about a year. I don't have a lot of details, though.
Okay. And why specifically does that incident bring some bad feelings or emotions about personal injury cases in general?
So like I mentioned about it taking a year, she, during that time, was having difficulty paying her medical bills. And so I just thought it was something that should have been resolved more easily, given that the pallet was there by mistake or error.
Okay. So is it fair to say your criticisms are a little bit more about the delays associated with the litigation process more than the type of case that it was?
I think that's probably fair. I don't know. I think it just gave me a poor opinion of how that was handled.
Okay. I want to thank you all for also filling out a questionnaire, a very detailed questionnaire as part of this process here today. And I want to follow up with juror number 6 on some things in the questionnaire. I noticed you said most slip and falls happen in stores as a result of customer inattention. Would you mind telling us your feelings on that?
So I guess I probably shouldn't have said most. I think many, just because I've heard stories about, people who have slipped or who have planted something and then slipped and tried to sue the store. But I don't have any real strong feelings either way. I mean, I know that a lot of slip and fall cases are certainly very valid, and I just, I think that each case has to be looked at separately, because I think there's a lot of different reasons and causes that things like this might happen.
Does anyone here have kind of that same initial reaction that a slip and fall, you may need a little bit more evidence to evaluate the case because you may be a little skeptical about the credibility of the plaintiff? Does anyone feel that way? Okay. Sticking with you, juror number 6, I also noticed on your questionnaire you said people who slip and fall at stores and claim bodily injury are probably lying. Tell me a little bit more about that.
Did I say that? I don't remember saying that. Wow. Well, again, I guess it's just stories I've heard. Maybe that's why I thought that, because just stories I've heard about people trying to cheat the system or do something dishonest.
Okay. Has anyone else heard similar stories about slip and falls and people being dishonest? Okay. Let's see. If a plaintiff slips, some people think it's probably their fault because they should be watching where they're going. Similar when a person trips, people think, well, you should have been looking at the ground. Why did you do that? How many of you feel this way? Okay, I'm going to go to juror number 13. Thanks for being here. Do you have any feelings one way or the other about slip and fall cases or people watching where they're going when they're walking?
Maybe it's because I'm not very careful. So I feel that it can't initially, yes, there needs to be evidence examined, but I feel like you can't just blame it on the person who slips and falls. I mean, that's part of safety protocol in the store or the establishment and OSHA standards that need to be, that need to be lived up to and followed on a daily basis. And yes, there's always going to be cases on both sides, with things, but I feel like it can't initially be, the blame can't be on the person. Someone could be completely watching where they're going, and sometimes you just can't help slipping. Or someone has poor balance or something like that. That's my feeling.
Okay. Juror number 2, any feelings on that?
I've not had a relative, never been involved in a slip and fall, so I don't really have strong views about whether that, as an initial matter, the blame lies the person or the business. So I guess I don't have any strong views, I guess I would say.
Okay. Has anyone here ever just slipped at a store, on the street, at their home? Okay. Number 15. Do you have a specific incident that stands out in your mind?
Yeah, I used to work at a retail store in New York, and there was a day that I tripped on a carpet and went into a shelf and split open the skin on my arm. And actually I still have a scar on my arm from it. And they bandaged me up and they sent me home for the day. But I mean, I wasn't looking where I was going. It never would have occurred to me to think that it was the company's fault. But that's just, I think, me personally, because I'm clumsy and I was also younger and in college and didn't really know a lot about the world of that. So, yeah, I think it just depends on the circumstances, and you have to look at everything that's happening.
You bring up a good word, and it's the second time I've heard it, clumsy. Who here has the kind of impression that if you slip and fall that you're just clumsy? Does anyone here have that feeling? Yeah, I think I heard it from 13 and 15. Okay, thank you. I want to ask, and I'll ask the judge for a time when I'm getting close to my time because I'm not keeping track.
About 5 more minutes.
Okay, thank you. Juror number 7, how do you feel about stores in general? Do you think it's impossible for a store to eliminate all potential safety hazards?
Well, I don't know that it's, am I unmuted? Can you hear me?
I can hear you, but your screen's frozen.
My screen is frozen. I don't know that it's impossible, and I think they do the best they can. I guess what I have a problem with is we all have insurance, the company has insurance, and yet we tie the courts up with all these personal injury cases to get more money, not just the amount to take care of hospital bills or, off of work for a little while, but we want more than that. That's what people seem to go after, where they want $100,000 instead of $20,000, whatever. And so I think that's kind of gotten out of hand in our country, where we just want more. I'm not saying that's in this case, each case has to be listened to and see what the evidence says, you know. But I think it's gotten out of hand. I guess that's my problem with this kind of case, is that it just puts up that suspicion that why wasn't your insurance claim enough? You know, there's never enough.
Well,
We
thank
have
you for your honesty.
what we call an accident, you know.
Mm-hmm.
Anyway, that's where my heart is.
It sounds like you have pretty strong feelings about this issue and this specific type of case, a personal injury slip and fall. Is that fair to say?
Well, not just slip and fall, even auto accidents. You know, they're accidents. And everybody's got insurance and, you know, but yet we have to hire a lawyer and go after $1 million or something. But to me, that's just wrong. Now, if it's true negligence and somebody left a puddle of water for 2 days on the floor or something, I don't know. I'm just really torn by this particular subject.
Okay.
Have to be honest.
It sounds
Right?
like you have pretty strong feelings about personal injury cases.
Yeah. And if the evidence
And
proves it, that's different. You know, if the evidence proves that somebody was totally negligent, that's a different story. But I don't know. I try to be open-minded, but I guess I'm not completely on this one.
Would it be fair to say that given these strong feelings, my client may be starting with a strike against her?
I hope not. I hope that the evidence is strong enough that I would still rule in her favor if that's what the evidence showed. But she might not want to take that chance on me, I suppose.
Based on your feelings, and would you have trouble keeping an open mind in this case as the evidence is presented? Do you think you would be skeptical from the beginning?
Well, I've worked very hard at being able to listen to both sides in lots of situations. In fact, yeah, I think I am good at listening to both sides even when I have a strong opinion.
Okay, Ms. Hayes, I think your time is up.
Okay.
We'll turn to Mr. Friedenthal now.
Thank you.
Donner, I'm trying to get back onto the screen here, and it's not, and there's a delay in what I'm saying and you're hearing.
Well, we are hearing you, so.
Okay, do you want me to do without the screen and not see? All right.
Can you see the jurors, the participants?
No.
Uh-oh.
No, I
Well,
got down.
we better. Stick with us, ladies and gentlemen. We'll get this whole glitch figured out.
Yeah, so everybody, I think we're going to just take a minute, and this is one of those glitches that I spoke to you about a little bit earlier, where we're just going to take a minute. You can stretch, and we're going to try and find so that the attorney obviously needs to be able to see the jurors when he is asking the question. So if the jurors will still hold tight, and we'll just be back with you in just a minute.
Yeah, in 15 minutes. In 15 minutes, we're going to be going to another jury panel to do the same thing, and you guys will have a break and be able to use whatever facilities you need at that point in time.
Right. For those of you who are still on the line and for our viewers out there, I want to let you know that one of the thoughts that we had now is we wanted to be able to, instead of having a large group voir dire, which we've seen in some of the other demonstrations, where there's just all these small tiles, we tried to figure out, well, what would happen if we had just smaller groups of jurors that come in and then are questioned individually? Does that increase the view of the attorneys? Are they better able to see the jurors and their responses? So that's just for a little bit of information. We just wanted to, this was one of those elements that we tried to take a look at and said, okay, how can we manage voir dire in a way that, that also allows the attorneys to get the best view of the jurors and their responses, and also minimizes that search on the screen there of who am I looking at and what are their responses. And obviously one of the things that we can also look at while Dan tries to get back up to speed is, is the elements of even jurors being able to respond and talk to the attorneys in a meaningful way. And so we won't interrupt the process with our jurors right now, but eventually at the very end of this process, we'll want to talk to them and find out how was the process of talking to the attorneys in this situation. Did you feel like you were able to respond to the questions? And then also we'll obviously talk about some of the technical glitches. For those of you in the audience, I know you're seeing a delay, and sometimes because of this system, because we're going to be moving jurors in and out of different rooms, we've asked them to be on their phones as well as on their computers. So that also manages, so there's another technical element there. So as you can see, there's a number of elements there that we're trying to manage as we look at this. I know a lot of people in the past have worked on a Zoom site, and we've seen a number of demonstrations on that, but we wanted to try a different platform to see, because we know that different courts around the country are using different platforms. And some are using WebEx, some are using a platform called Blue Jeans, some are using a few different platforms. So this is all of us trying to kind of figure out, as we are managing some of the technological issues, of how do we manage to basically get good quality information of jurors. And I think with Juror 7, who I think can still hear us right now, at some point,
yes,
when we move her into the room, we'll be able to fix her so that her screen isn't frozen. But this obviously points out the necessity for what we call a technology bailiff, someone who obviously is very proficient in a courtroom staff, who might be able to say, okay, we're going to take a quick break. I want to fix a technology issue that one of the jurors is having. So these are the things that we've sort of looked at as we've gone through there. Dan, are we about ready, or are you still trying to find a way back on?
Well, here's the problem. So I hear you on my computer, even though I've logged off of the program. So I don't know if that indicates anything. And then I tried to log back in. And just give me one moment.
While Dan is logging back in, Dan, just let me know when you're ready. I'm going to cover a couple of other quick points here. For those folks who are watching out there, the online courtroom project has also compiled a list of issues, basically considerations, including many of the things that we're actually experiencing right now, for the courts to look at as they're dealing with this, including, how the courts can manage a situation like this. Right now, we're doing a situation where our jurors are actually at their homes, but we do envision a time where courts may want to have more control over their own, over juror connections and more consistency in pictures. And so we imagine that there might be a time where courts might want to say, okay, we're still going to have jury selection. Jurors may actually come in to an administrative office, and they may be able to sit at workstations where there might be a bailiff that can oversee them and supervise kind of what they're doing, and there's more consistent connections. So there's a variety of options that we've looked at that the courts can also use to sort of manage some of the technology issues and some of the also control issues that I know are concerning. Of course, every jurisdiction has different resources. One of the concerns that we've heard in this whole situation is from a number of attorneys who have said, well, what about technology disparity? What if people don't have computers or they really don't have good internet connections? And so one of the things we've thought about is, well, can the courts partner with some of the technology companies to even provide Chromebooks? I know in Arizona, they're looking at having a telephone provider like AT&T provide modems for jurors who may not be in good internet areas. So there's all kinds of different solutions that are possible depending upon whether courts want to tackle this or not. Again, as we've seen today, there's no perfect solution. And so what we try to do is try to find out, okay, where is the problem, if it's an internet connection or if it's computer equipment, and then what might be a solution that might address that particular problem. Why don't we do this? Do we want to take a quick break? Where are we at? Dan, are you still trying to log back on? I think we've lost Dan for now. Why don't we do this? We are at, on the West Coast here, I think we are at 10:51. Why don't we take an early break?
Okay.
So for those of you who are in the Midwest, this would be at 12:52 as it is now. Why don't we take a quick break? Why don't we come back at 11 o'clock, which would be 12, which would be it would be 11 o'clock on the West Coast. It would be 1 p.m. Central Time, and for those of you who are on the East Coast, it would be 2 p.m. And why don't we take a quick break when we come back at that point, and hopefully we'll be up and running at that point, okay?
All right. Ladies and gentlemen of the jury, don't discuss this matter amongst yourselves or with anyone else, and don't form or express any opinions or conclusions. We'll see you back at about 8 minutes. Can all of you prospective jurors hear me at this point? I'm not quite sure what's happening, but there we go.
Okay, we are back at 11 o'clock right now. We still are missing juror number 13 and juror number 7. So hopefully we can get them back in a second and begin again. Judge Hastings, as an option, if we can't get Dan back on, one of the things we may want to do is move on to our second panel, and then Jillian Ms. Hayes can start voir diring that until Dan is back up to speed.
We can do that.
Okay. Well, let's wait for our juror number 7, and then we will get started again. If Dan is not available and he's still having some technical problems, we're also working right now on co-counsel that also may be able to come in and ask some questions of the jurors. Okay.
There's number 13.
There's number 13.
There's Dan.
Oh, looks like we've got
We
Dan.
might have Dan.
There we
There's
go.
Mr. Freeman Paul.
We have
right.
we have Dan back.
We do.
Excellent.
We're just waiting for juror number 7 now.
Irene, are we still looking for juror number 7?
We have juror number 7 in the audio side. Let me go ahead and just open up her line. My apologies. You're fixing juror number. Hello, juror number 7.
Yes, I'm here, but there's no audio no video for some reason.
Okay. I'll get you in with me. You want to go ahead and just continue with your situation? I'll be right back.
We're going to continue. Dan's going to proceed. Maybe a little bit shortened version of what you had planned, Dan, and then we will move on while juror number 7 gets back up to speed.
Okay, I apologize to
Juror
everybody.
number 7 can hear us, so go ahead, Mr. Freeman Paul.
Okay, sorry about that, folks. Technical difficulties. Hopefully no one will hold it against Walmart that my computer failed me. But do any of you feel, with a showing of hands, that in a case like this, where it's an individual suing a retail store or a commercial business, that they would tend to favor an individual over a company, just because of that status? Okay. Do any of you feel that because the case got this far, namely a jury trial, that it necessarily has some merit? Does anyone feel that way? Can all of you wait till the end of this this case, after you've heard all of the evidence, the arguments, and the judges instructed you on what the law is in the case? Can you all wait till the end before you make your decision in this case? Keep an open mind. Okay. Thank you. Do any of you have a problem philosophically, if the case supports it, the facts and the law supports it, in rendering a verdict in favor of the defendant, where the plaintiff would get nothing at the end of the day, if that's what the evidence points to? Would anyone have a philosophical problem with Ms. Mulligan getting nothing at the end of this trial? Okay. Do any of you believe that Ms. Mulligan and perhaps her attorney are entitled to something just by participating in a jury trial, just by bringing the trial here and carrying boxes in and having Post-its and things like that? Do any of you believe that just because they're going through that exercise, they're necessarily entitled to something? Okay. Do any of you believe that an accident that occurs on a commercial property is necessarily the property owner or the occupant's fault, just because it happened on that premises? Does anyone feel that way? Do any of you presently have a lawsuit pending Well, you're either a plaintiff or a defendant.
No.
Have any of you been sued before? Do any of you have any of you worked retail before? Okay, juror number, and your number is very small there. Juror number 15. Where did you work? I can't hear.
I worked at JCPenney at Park Meadows for a while in high school, and then I worked at Aeropostale in New York all throughout college.
Okay, so clothing stores and home furnishing stores and things like that, correct?
Yes.
Is that right? All right, and when you started working at JCPenney's and the other place you mentioned, did you get instructions about looking out for tripping hazards and things like that?
Not that I recall, no.
Okay. Who else had their hand up? Juror
Juror
number,
number 13.
Yes. Where did you work?
I worked at Wet Seal clothing company, and I worked at Nordstrom.
Okay. And were you trained to look out for tripping hazards and things on the ground? And no.
Not that I recall.
Did juror number 15 and juror number 13, when you were going to work each day, JCPenney's and Nordstrom's, did you just kind of use your common sense as to if you saw a spill, you would tell somebody or do something yourself?
Yes.
Yes. Yes.
Okay.
And we also had standards in what we wore. And so, I mean, so you needed to wear appropriate shoes so that you wouldn't fall.
Okay.
And
yeah, same. We had to wear non-slip shoes.
Exactly. Yeah.
Did you both work as cashiers?
I think at Steel I did, not at Nordstrom. A while ago.
When you were a cashier, was part of your job to keep the area on the counter and the floor around the checkout stand clean?
I think I've always been an OCD clean freak, so I think it was in my nature to do that. They may have trained us. That may have been like a little laminated sheet that they gave us, but I'm not sure.
Yeah. And last question is, have any of you seen or heard anything thus far that would make you tend to favor one side or the other than my computer going out? No? Okay. Thank you, Your Honor. That's all I have. Oh, juror number 10.
Yeah. So like I mentioned earlier, I do have an aunt who was injured in a store. And when you ask that question about, do you think somebody's company is automatically at fault? I don't know if I would phrase it that way. I don't know if I would say they're automatically at fault because then they did something wrong, but I do think it's automatically their responsibility, if that makes sense.
What if there's a video of someone just tripping over their own foot? Would you still feel the same way?
I don't know. I just know that there's a lot of things that could be done to prevent accidents, and I think there's probably, in most cases, something that could have been done to make that environment safer.
Okay.
I don't think there are instances where it's probably totally just your fault as a person, but I think there's almost always like two sides of it.
Yeah, and you understand that thus far, just the judge indicating what the case is about and plaintiff's counsel and myself just asking you general questions about things, you haven't heard any evidence yet. You understand that?
Mm-hmm. Yeah.
Okay, and the evidence comes from witnesses and documents of things. You understand?
Yes.
Can you keep an open mind, even though that unfortunate incident happened to your aunt? Can you keep an open mind and give both Walgreens and Ms. Mulligan the benefit of them putting their case on and then waiting till the end to see what you think?
I think so. I think it would help to hear everything, and I think it's important to be open-minded. I think I would have to hear a lot.
Thank you, Your Honor. I don't have any further questions.
All right, well, ladies and gentlemen of the jury, we're going to do what's called a sidebar conference now, just the attorneys and I. We'll put you off the screen, and please don't get off your computer. We're going to put you off in a different room because we're going to then talk to the next set of prospective jurors and go through this same process. So we probably won't need to see you for at least another 30 minutes or so is my guess. Thank you very much.